Welcome to Justice Insight Cam. We showcase raw bodycam recordings of actual law enforcement stops. Beyond the dramatic footage, we carefully interpret the law, the factual reality, and the profound lessons hidden in plain sight. Let's focus on the pursuit of justice.
Ma'am, step away from that vehicle and put your hands where I can see them.
Legal basis.
Ma'am,
I'm pumping gas.
that vehicle matches a stolen car description in this area. I need to verify ownership.
Officer, my name is Patricia Renee Coleman. I am a sitting United States Federal District Court judge.
Ma'am.
I'm sitting here.
At precisely 8:47 on a warm Tuesday evening in Buckhead, Atlanta, Georgia, a routine stop at a Shell gas station on Peachtree Road that should have lasted no more than 2 minutes turned into a 26-minute racial profiling incident that would be replayed on every major news network in the country. The combination of body camera footage and the gas station's own surveillance system recorded every second, and those seconds would later be submitted as evidence in one of the most significant civil rights lawsuits filed against a municipal police department in the state of Georgia in over a decade. The footage racked up 22 million views in less than 4 days. Legal analysts examined it frame by frame. Law professors added it to their course syllabi. And a woman who had devoted her entire adult life to working within the justice system found herself on the opposite side of it, not as a judge, but as a black woman in America who had just been told that her luxury vehicle did not match her profile. But this was not your typical viral police encounter video. This one was different. This was a sitting federal judge, a woman with 20 years on the bench, a Harvard law graduate, a former federal prosecutor, a woman who had presided over hundreds of civil rights cases, who had written landmark opinions, an unlawful search and seizure, who knew constitutional law not just as an academic exercise, but as the foundation of her entire professional life. She had spent 2 decades ruling on exactly the kind of encounter she was now experiencing from the other side. What happened next would stun the Atlanta Police Department's command staff, ignite a firestorm of national outrage, force a federal investigation into the department's traffic stop practices, and result in a $13.8 million settlement that sent a message heard all the way to Capitol Hill. Before we continue, can you do me a favor? Drop a comment and let me know where you're watching from. And if you have not already, please hit that subscribe button right now. This story gets more intense with every minute, and I promise you, you do not want to miss what comes next. Judge Patricia Renee Coleman was not your average 47-year-old. While most people her age were winding down their careers, Patricia was at the absolute peak of hers. Appointed to the federal bench at just 38 years old, she was one of the youngest federal judges ever confirmed in the Northern District of Georgia. She had been nominated after a distinguished career as an assistant United States attorney, where she had successfully prosecuted over 200 federal cases, including several high-profile public corruption trials that made national headlines. Patricia grew up in Southwest Atlanta, the daughter of a high school principal and a registered nurse. She was the first person in her family to attend college on a full academic scholarship. She graduated summa cum laude from Spelman College, then went on to Harvard Law School, where she graduated in the top 5% of her class and served as editor of the Harvard Law Review. Her resume was staggering. She had clerked for a federal appeals court judge. She had argued before the 11th Circuit Court of Appeals 14 times. And she had been profiled in the National Bar Association magazine 3 times. She had received the American Bar Association's prestigious Thurgood Marshall Award for her written opinions on civil rights and constitutional protections. She sat on 2 judicial oversight committees. She had personally trained over 30 new federal law clerks. She had written opinions that had been cited by other federal courts more than 80 times. She was also by every account of every colleague who had ever worked with her. One of the most measured, composed, and intellectually formidable human beings in any courtroom she had ever entered. Her law clerks described her as someone who never lost her composure, who never raised her voice, who could dismantle the most arrogant attorney's argument with a single quiet sentence and a look that made the whole room go still. She was also a black woman, and on this particular Tuesday night, that was the only thing Officer Dale Hutchkins saw. On the evening of September the 9th, Judge Patricia Coleman had just wrapped up an exceptionally long day in federal court. She had presided over closing arguments in a complex securities fraud trial that had been going on for 6 weeks. The jury had been sent to deliberate. She had then spent 3 additional hours reviewing written briefs for a separate civil rights case scheduled to begin the following Monday. By the time she gathered her briefcase, said goodnight to her clerk, and walked out of the Richard B. Russell Federal Building on Spring Street in downtown Atlanta, it was after 8 o'clock in the evening. She was wearing her professional attire, a tailored charcoal blazer, and slacks. She carried her judicial credential badge in her coat pocket, as she always did when traveling to and from the courthouse. She climbed into her personal vehicle, a black Genesis GV8 SUV, a car she had purchased 14 months earlier and paid for in full. She pulled out of the parking structure and headed north on Peachtree Road toward her home in the Buckhead neighborhood, a drive she had made hundreds of times. The night air was still warm, that particular soft warmth that Atlanta holds onto. Long into September, the city lights were glowing. She had her jazz playlist on Low Miles Davis. She would later recall in her deposition, she stopped at the Shell station at Peachtree Road and West Paces Ferry Road to fill up her tank. She pulled up to pump number 4. She got out of her car. She inserted her card. She began pumping gas. She was not speeding. She was not swerving. She was not behaving erratically. She was not trespassing. She was not in a restricted area. She was not under the influence of anything. She was a professional woman on her way home from work, pumping gas at a public gas station, doing exactly what millions of Americans do every single evening without incident. Then, Officer Dale Hutchkins pulled his cruiser into the gas station. Patricia noticed the patrol car immediately. She did not panic. She did not become anxious. She felt something else entirely. A familiar, heavy awareness that she later described in her own words as the particular exhaustion of knowing what is about to happen before it happens, because it has happened before, and because you have spent your entire career reading the case files of people to whom it happens every single day. She kept her hand on the pump. She waited. Officer Dale Hutchkins had been with the Atlanta Police Department for 22 years. He was 51 years old. He was assigned to Zone 2, which covered portions of Buckhead and the surrounding neighborhoods by his own departments. Records. He had conducted more discretionary field contacts and vehicle stops in predominantly white neighborhoods than any other officer in his zone over the previous 3 years. He had 6 prior complaints filed against him by members of the public, 5 of which involved black individuals alleging racially motivated stops or harassment. None of those complaints had resulted in formal discipline. His supervisors had consistently rated him as satisfactory in his annual reviews. He had received accommodation 7 years earlier for a felony arrest. He considered himself an experienced officer who relied on his instincts. Those instincts on this particular Tuesday night told him that a black woman driving a black Genesis GV80 at a gas station in Buckhead did not belong there. He stepped out of his cruiser and walked toward her. "Excuse me, ma'am," Officer Hutchins said, his tone already carrying the particular brand of authority that assumes the answer before the question is asked. "Can I ask what you're doing here tonight?" Patricia looked at him. "I'm pumping gas," she said. Calm. You measured precisely the way she spoke from the bench. "Is this your vehicle?" And that was where it started. That single question not asked of the white man pumping gas 2 pumps over in a BMW. Not asked of anyone else in that gas station on that night. Asked of her. Yes, Patricia said, "It is my vehicle. Can I see some ID and your registration?" Patricia paused, and in that pause, 20 years of federal judicial experience and constitutional scholarship clicked into place like a key entering. A lock because she knew with absolute precision what the law required of her in this moment and what it did not. "Officer, am I being detained?" she asked. "Or am I free to go?" Hutchkins shifted his weight. "Ma'am, I'm just asking some questions. Understand that. But I'd like to know if I am being detained or if I am free to go. Or I'm going to need you to cooperate. Cooperating is not the same as consenting to a search or providing identification without legal basis," Patricia said. Her voice is steady, as if she were explaining a legal standard to a first-year law. "Clark, under Terry versus Ohio, you need reasonable, articulable suspicion of criminal activity to detain me. Under Georgia law, I am not required to provide identification unless I am being lawfully detained. So, I will ask you one more time. Am I being detained or am I free to go?" Hutchkins stared at her. This was the moment the body camera captured everything. You can see it on his face, the flicker of something not anger yet, but confusion. The slight adjustment of his stance, the way his jaw tightened. He had not expected this. In years, he had learned that most people, when approached by an officer with that tone, with that posture, with that badge, simply complied. They handed over their ID. They answered the questions. They did not cite Supreme Court precedent at a gas pump. "Where did you get this vehicle?" he asked, pivoting. And this is where Patricia Coleman, federal judge, did something that most people in her position would never have the composure to do. She reached into her coat pocket slowly, deliberately, and she produced her federal judicial credentials. "My name is Judge Patricia Renee Coleman," she said. "I am a United States federal judge for the Northern District of Georgia. This vehicle is registered in my name. I purchased it 14 months ago from a dealership in Alpharetta. The registration is in the glove compartment, which you do not have my consent to access. And I want to be very clear with you right now. Everything you are doing is being recorded by your body camera, by the gas station surveillance cameras, and by my own phone, which I am now activating." She reached into her purse and placed her phone on the roof of the car with the camera facing him. Hutchkins went still. Quick question for everyone watching. Have you ever been stopped or questioned by police in a situation where you had done absolutely nothing wrong? Drop your answer in the comments right now. I want to hear your stories. "Ma'am, I'm just doing my job." "Your job," Patricia said, "or does not include approaching a woman who is lawfully pumping gas and demanding she prove that her car belongs to her without any articulable legal basis while not approaching any other individual at this gas station tonight. I want your name, your badge number, and the name of your supervising officer, Officer Dale Hutchkins, badge 4721. Thank you. And your supervisor, Sergeant Linda Pryor. Thank you, Officer Hutchkins. I am going to finish pumping my gas. I am then going to get into my vehicle and drive home. You are free to run the plates on this car, and when you do, you will find that it is registered to Patricia Renee Coleman at an address in Buckhead. I would strongly encourage you to think very carefully about what you do next." She turned back to the pump. Hutchkins did not leave. Vainuk, what had happened in the next 11 minutes is where this encounter crossed every line. Instead of running the plates, instead of walking back to his vehicle, instead of doing any of the reasonable things that any reasonable officer would do in that moment, Hutchkins doubled down. He called for backup. He told the dispatcher he had a potential stolen vehicle situation. He asked Patricia to step away from the vehicle. He touched her arm. He touched a federal judge's arm without consent without legal basis, at a gas pump. While she had done absolutely nothing wrong, that was the moment everything changed. The body camera captured Patricia's reaction. She did not flinch. She did not raise her voice. She looked down at his hand on her arm. Then she looked up at him, and in a voice so quiet, the camera almost did not pick it up clearly. She said 4 words, "Remove your hand." Now he did 2 additional officers arrived within 4 minutes. They quickly assessed the situation, ran the plates, confirmed the vehicle was registered to Patricia Coleman, and immediately recognized that their colleague had made a catastrophic error. One of the responding officers, a younger officer named Torres, can be seen on body camera footage pulling Hutchkins aside and speaking to him in a low, urgent voice. Hutchkins shook his head. Torres shook his back. The encounter ended with no arrest, no citation, no warning. Patricia Coleman got into her Genesis JF80 and drove home. The entire encounter had lasted 26 minutes. 26 minutes that would end Dale Hutchinson's 22-year career and cost the city of Atlanta $13.8 million. Now, most people who experience what Patricia experienced that night might go home, stew in their anger, maybe call a friend, maybe post something on social media, maybe write a letter that never goes anywhere. But Patricia Renee Coleman was not most people. She was a federal judge with 20 years of experience in exactly this kind of law. And she did not go home and stew. She went home, sat at her kitchen table, and for the next 4 hours, she wrote. What she produced was not a simple complaint form. It was not a 2-paragraph email to Internal Affairs. What Patricia Coleman wrote that night was a 43-page formal legal memorandum. It was structured like a federal brief. It cited case law. It cited Atlanta Police Department standard operating procedures chapter by chapter. It cited the 4th and 14th Amendments. It included a detailed timeline with timestamps derived from her own phone recording and the gas station's publicly available surveillance footage request process. It identified every specific policy violation she believed had occurred. It named every officer present. It outlined the precise legal theory under which she believed the encounter constituted racially discriminatory policing in violation of the Equal Protection Clause. It was the kind of document that a senior civil rights attorney with 30 years of experience would produce, because in a very real sense, that is exactly what Patricia Coleman was. She filed it the following morning with the Atlanta Police Department's Office of Professional Standards, with the City of Atlanta's Inspector General, with the United States Department of Justice Civil Rights Division. And she attached to every single copy a USB drive containing the full video from her phone. The Atlanta Police Department's Office of Professional Standards received Judge Coleman's memorandum on a Wednesday morning. By Thursday afternoon, Officer Dale Hutchkins had been placed on administrative leave with pay pending an internal investigation. That almost never happens that fast. Most internal affairs investigations take weeks just to be assigned to an investigator. The fact that Hutchkins was placed on leave within 36 hours tells you everything you need to know about how seriously the department took Patricia Coleman's filing. Do you think placing him on leave was enough of an immediate response? Let me know what you think in the comments below. The investigation was assigned to Deputy Chief Sandra Okafor, head of the department's Professional Standards Division. She was one of the most experienced investigators in the department's history, with a reputation for thorough, unbiased reviews. She pulled every piece of available footage immediately. The body camera from Hutchkins, the body camera from Officer Torres, the body camera from the third responding officer, the Shell gas station's exterior surveillance, which had captured the entire encounter from a different angle, and Patricia Coleman's own phone recording, which had captured Hutchins' face and words with sharp, uncompromising clarity. Deputy Chief Okafor watched the footage once, then she watched it again. Then she called in her senior investigator, Sergeant Marcus Webb, and watched it a third time with him in the room. The footage confirmed everything Judge Coleman had written. Every single point. Not approximately, not mostly. Every single point. Hutchkins had no articulable legal basis for the initial contact. He had not observed any traffic violation. He had not received any report of criminal activity matching Patricia's description or vehicle. He had not run the plates before approaching her. He had approached only her among all individuals present at the station. His question, asking whether the vehicle belonged to her, before any other question, had no legitimate law enforcement basis. His request for backup, citing a potential stolen vehicle situation, was made with no supporting evidence whatsoever, and his physical contact with her arm occurred without legal authority and without her consent. But there was something else in the footage that made this case even more serious. In Deputy Chief Okafor and Sergeant Webb reviewed the body camera footage from Officer Torres, the younger officer who had responded as backup. In that footage, after Hutchkins had already confirmed the vehicle's registration and Patricia had driven away, Torres turned to Hutchkins and said, clearly audible on the recording, "Dale, what were you thinking? She told you who she was." And Hutchkins, who did not know his body camera was still recording, said 8 words that became the single most damaging piece of evidence in the entire case. He said, "I don't care who she is. She doesn't belong here. He does not care who she is. She does not belong here. Not in a stolen car, not at the scene of a crime, not doing anything illegal. She does not belong at a gas station in Buckhead driving a luxury SUV while being black." That was his reasoning, captured on camera, in his own voice, in his own words. The investigation took 19 days in total for this type of investigation that is extraordinarily fast. Most use of force and civil rights complaint investigations take months. But Deputy Chief Okafor had everything she needed. The evidence was not ambiguous. The documentation from Judge Coleman was not just thorough. It was prosecutorial in its precision. There was nothing to debate. Everything was documented. Everything was on camera. Everything was undeniable. The Office of Professional Standards released its findings in a formal 14-page report. The findings were as follows. Officer Hutchkins had no reasonable articulable suspicion to initiate contact with Judge Coleman. His contact was not supported by any observable traffic violation, any report of criminal activity, or any other lawful basis. His request for identification was unlawful under the circumstances. His request for backup, citing a potential stolen vehicle, was made without factual basis and represented a misuse of departmental resources. His physical contact with Judge Coleman's arm constituted unlawful touching under Georgia law and a violation of departmental use of force policy. His statement captured on body camera that he did not care who she was and that she did not belong there constituted direct evidence of discriminatory intent. And his failure to immediately disengage after reviewing her credentials represented a pattern of escalation inconsistent with department training and policy. The department recommended immediate termination. Officer Dale Hutchkins was fired. His 22-year career ended because of a 26-minute encounter at a gas pump because he decided that a black woman in a luxury SUV at a gas station in Buckhead did not belong there. He was 51 years old. He had never faced formal discipline in over 2 decades, and he lost everything in 19 days. Judge Coleman filed her civil lawsuit in federal court 30 days after the incident. The case was assigned due to obvious conflict of interest with the Northern District to a judge in the Middle District of Georgia. The complaint named Officer Dale Hutchkins personally, the City of Atlanta, and the Atlanta Police Department. It alleged violation of her Fourth Amendment rights against unlawful seizure, violation of her 14th Amendment right to equal protection, violation of Georgia state civil rights statutes, assault through unlawful physical contact, and negligent supervision by the department given Hutchkins 6 prior complaints. The city's legal department initially indicated they intended to contest the lawsuit. That position lasted approximately 3 weeks until their attorneys reviewed the body camera footage and Patricia Coleman's 43-page memorandum in detail. After that review, the city's legal team reportedly advised the city council in a closed session that contesting this case in front of a federal jury, with that footage, with those 8 words on tape, was not a viable legal strategy. Settlement. Negotiations began and concluded relatively quickly. The Atlanta City Council approved a settlement of $13,800,000. It was the largest civil rights settlement in the history of the Atlanta Police Department. $13,800,000 for pumping gas. When the footage hit the internet, it detonated. News outlets picked it up within hours. It was the lead story on 3 national cable news networks by the following morning. Legal analysts appeared on television, breaking down every moment of the footage. The clip of Hutchinson's 8 words, captured on Torres's body camera, was played. On loop, politicians issued statements. Civil rights organizations held press conferences. Bar associations across the country issued formal statements of support for Judge Coleman. Social media did what social media does. The footage was shared millions of times. The hashtag Justice for Judge Coleman trended nationally for 4 consecutive days. Her name was mentioned in over 3 million tweets in the first week. Legal educators posted breakdowns of the constitutional issues. Former law enforcement officers posted commentary. Activists posted it as evidence of systemic patterns. Ordinary people posted their own stories in response. Some people praised Patricia for how she handled the encounter. They praised her composure, her precision, her refusal to be intimidated, and her decision to pursue every available legal avenue. Others criticized her, arguing she should have simply handed over her ID to de-escalate the situation. Some said she was being unnecessarily confrontational. Some said she put herself at unnecessary risk by pushing back. Some questioned whether she would have filed the lawsuit if she had not been a judge, if she had not had the resources and the platform. But here is what nobody could deny. Patricia Coleman was right about everything. Every legal point she made at that gas pump was accurate. Every violation she identified in her 43-page memorandum was confirmed by the investigation. Every argument her attorneys made in the civil complaint was validated by the settlement. She was right from the first moment to the last. After the settlement was announced, the Atlanta Police Department announced a series of mandatory changes. All officers in the department were required to complete a new 8-hour constitutional policing training course, which specifically covered the legal standards for initiating civilian contact, the requirements of reasonable articulable suspicion, the Equal Protection Clause, and racially discriminatory policing and proper de-escalation procedures. When citizens invoke their legal rights, officers were required to articulate specific factual basis for all non-traffic stop civilian contacts in their incident reports, and those reports were now subject to supervisory review within 24 hours. The department implemented new early warning system for tracking patterns of civilian complaints by individual officers. Supervisors who failed to act on complaint patterns would themselves face disciplinary review, and the department, for the first time in its history, created an independent civilian oversight panel with actual subpoena authority. Essentially, they built the training program that Patricia Coleman could have designed herself, because in many ways she had her 43-page memorandum had outlined not just the violations, but the systemic policy failures that allowed them to occur. And after the footage went viral, something else happened. 11 other individuals came forward with formal complaints against Officer Dale Hutchkins. 11 people who had been stopped, questioned, or detained by Hutchkins over the previous 8 years, and who had never reported it because they did not believe anything would come of it. A 23-year-old college student, a 35-year-old physician, a 40-year-old real estate agent, a retired school principal who was 68 years old, all black, all stopped in the Buckhead zone. All told in some form or another that they did not belong where they were found. This was not an isolated incident. It was never an isolated incident. It was a pattern that had been tolerated, ignored, and enabled for nearly a decade. And it raises the question that this story, like so many stories like it, ultimately demands we ask how many Officer Hutchinson are out there, still on duty, racking up complaints that go nowhere, stopping people who do not have 43-page memorandums and federal credentials and the specific expertise to fight back. As of today, Judge Patricia Renee Coleman remains on the federal bench in the Northern District of Georgia. She returned to work the Monday after the incident, as if nothing had interrupted her schedule, because in her mind, it had not. She had done what the law required. She had exercised her rights. She had documented the violation. She had pursued the remedy. That was not an extraordinary act to her. That was simply what the legal system was designed to do. When it worked correctly, she later used a portion of her settlement to establish the Coleman Foundation for Constitutional Literacy, a non-profit organization that provides free legal rights education to communities across Georgia. The foundation has trained over 14,000 individuals since its establishment, teaching ordinary people the same principles Patricia used at that gas pump: what your rights actually are, what officers can and cannot legally do, how to document an encounter, how to file a complaint, how to pursue legal remedies. She also published a law review article in the Harvard Law Review titled "The Pretextual Stop as an Equal Protection Violation," which has since been cited in 3 federal court opinions. Officer Dale Hutchins, as of the filing of this script, is no longer employed in law enforcement anywhere in the state of Georgia. He has not made any public statements since his termination. Here is a question for you. If you were in Patricia's position that night, would you have handled it the same way? Or would you have just handed over your ID to end the encounter faster? Comment below. I genuinely want to know what you think. Let us talk about the bigger picture here, because this story is about much more than one encounter at one gas station on one night in Atlanta. This story is about the presumption of criminality. It is about the specific way that some members of law enforcement have been conditioned consciously or not to view black success, black wealth, black presence in certain spaces as inherently suspicious. Patricia Coleman was not stopped because she was doing something wrong. She was stopped because she was doing something right. She had worked for 20 years, built one of the most distinguished legal careers in her state, yes, earned the right to drive whatever car she chose, wherever she chose to drive it. And that achievement itself became the reason someone questioned whether she belonged. This story is also about the power of knowledge. Most people do not know their constitutional rights with any specificity. They know them the way people know, the words to a song they have not heard in years, vaguely, incompletely, enough to hum along, but not enough to recite every verse. And some officers count on that. They count on people not knowing that you are not required to provide identification in every state, simply because an officer asks. They count on people not knowing the legal standard required to detain someone. They count on people not knowing that invoking your rights is not the same as being uncooperative. When you encounter someone like Patricia Coleman, someone who can cite the specific case law, who can name the specific policy section being violated, who can explain in precise legal language exactly where the officer has crossed the line, the entire dynamic shifts. The badge does not automatically win. The uniform does not automatically command submission. Knowledge becomes the equalizer. And this story is about accountability, and specifically about who gets it. Patricia Coleman got accountability because she was a federal judge with the expertise, the resources, and the platform to pursue it relentlessly. She got accountability because she produced a document that investigators could not ignore. She got accountability because the footage was undeniable. But what about the 11 other people who came forward after the footage went viral? What accountability did they receive for their encounters with Hutchkins? What accountability do the millions of people receive who have similar encounters but do not have 43 pages of constitutional law at their fingertips and a law degree from Harvard? The knowledge gap is not just a personal disadvantage. It is a structural one. It is built into the system, and it is one of the primary reasons that encounters, like the one Patricia Coleman experienced, continue to happen thousands of times every single day across this country, mostly to people who do not have the tools to fight back. Let us address something that came up in the comment sections when this story went viral, because it is worth engaging with honestly. Some commenters said that Patricia was being unnecessarily combative, that she should have just shown her ID. He let the officer do his thing and moved on with her night. They said that refusing to comply, even lawfully, escalated the situation and put her in unnecessary danger. And on a purely tactical level, they are not entirely wrong. There is a version of this where Patricia hands over her ID, Hutchkins runs. It confirms she's done nothing wrong, and the encounter ends in 3 minutes with no lawsuit and no termination and no $13.8 million. But here's the thing, that version of the story is not a victory. That version of the story is exactly the problem. Because in that version, Hutchkins walks back to his cruiser having learned nothing, having faced no consequence, having been validated in his decision to approach a black woman pumping gas and demand she prove she belongs there. Near and the 11 other people who came forward after the footage went viral. Their encounters still happen. The pattern continues because nothing challenged it. As for the argument that invoking your rights puts you in danger, that is absolutely a real consideration. Patricia knew it. She said so in later interviews. She was not unaware that the same encounter with a different officer, in a different mood, in a different circumstance, could have gone in a much darker direction. She calculated that risk. She decided that her rights were worth asserting. She decided that the documentation of this encounter, win or lose, had value. And the fact that exercising a constitutional right has to be calculated as a risk in the first place tells you everything you need to know about the problem this story is really about. So, what is the lesson from Patricia Coleman's story? What should you actually take away from this? First, know your rights specifically, not generally. Not just that you have them, but what they actually mean in practice. Know the difference between being detained and being free to go. Know what reasonable, articulable suspicion actually requires. Know what you are and are not legally obligated to provide. That knowledge is not just academic, it is practical, it is protective. It is the difference between an encounter that ends in your favor and one that does not. 2. Second, document everything in real time whenever it is safe to do so. Your phone is one of the most powerful accountability tools available to you. Activate it. State the date and time and location clearly. Keep it visible. In the footage from Patricia's phone combined with the body camera footage created an evidentiary record that no one could dispute. Documentation does not just help you, it helps everyone who comes after you. Third, the complaint process exists for a reason. Use it. Use all of it. Not just the department's internal affairs office, but the Inspector General, the Department of Justice, your city council representative, every avenue available. Patricia did not file one complaint. She filed with multiple oversight bodies simultaneously. That breadth of filing made it impossible to bury Forth. Understand that accountability is not automatic. It has to be pursued relentlessly, professionally, thoroughly. Hutchkins had 6 prior complaints that went nowhere. Those complaints might have stopped him years earlier if they had been pursued with the same precision that Patricia brought to hers. The system does not move unless it is pushed. Fifth, your story has value even when the outcome is uncertain. 11 people came forward because of Patricia's footage. 11 people who had carried their experiences in silence for years. You do not always know in advance whether your documentation, your complaint, your refusal to be silent will result in accountability, but you know that silence guarantees nothing changes. 1 woman, 1 gas pump, 26 minutes, and the largest civil rights settlement in Atlanta Police Department history. That is the power of knowing your rights. That is the importance of using them. That is what happens when one person refuses to be silent, refuses to accept the presumption that she does not belong, and refuses to let the encounter end without consequence. Final question for you. What is one thing you learned from this story that you did not know before? Drop your answer in the comments below, and do not forget to subscribe because we cover real stories like this one every single week, and you do not want to miss what we have coming next. This story matters because it is not just about Patricia Coleman and Officer Hutchkins. It is about every black professional who has ever been made to feel like a suspect in a space they earned the right to occupy. It is about every person who has ever been stopped not for what they did, but for who they are. It is about every complaint that sat in a filing cabinet for years because the system counted on the person filing it not having the resources or the knowledge or the persistence to see it through. It is about every officer who was never held accountable, not because there was no evidence, but because no one ever pushed hard enough. Patricia Coleman's story shows that you can know your rights and assert them. You can document the encounter and use that documentation. You can pursue every legal remedy available and see it through to the end. And sometimes you can win, not just for yourself, for 11 people who came forward after your footage went viral, for 14,000 people who learned their rights through the foundation you built with your settlement, for every law student who will read the Law Review View article you wrote, and for every federal judge who will cite it in an opinion. Not every story ends this way. Not every encounter results in justice. Not every complaint leads to change. Not every settlement gets paid. Not every officer gets fired. But this one did. And that matters. It matters because it proves the system is capable of accountability when the evidence is undeniable, and the pursuit is relentless, and the person at the center of the story refuses, absolutely refuses to let it go. That is Patricia Coleman's legacy. Not just $13.8 million, not just one termination, not just one department's policy reforms. Her legacy is showing millions of people that a black woman at a gas pump, tired after a 14-hour day, with nothing but her phone, her knowledge, and her refusal to accept injustice can change things. That is the lesson. That is the story. And that is why it matters.
Thank you for watching today's analysis. If you found this information valuable, please like, share, and subscribe to Justice Insight Cam. Stay vigilant, stay secure, and join us for our next detailed report.